The position in owners of the motor vehicle vessel Lydian S versus Caltex Oil Kenya Limited, 1989 KLR1, remains as instructive today as it was when it was first pronounced, that jurisdiction is everything and a court that proceeds without it does so in vain. It is therefore necessary, before turning to the substantive grievances raised in these petitions, to resolve the threshold jurisdictional question that permeated the pleadings and submissions of almost all parties on whether the impeachment of a deputy president is amenable to judicial scrutiny or whether it falls exclusively within the political domain of parliament and is therefore beyond the reach of courts. The respondents urge this court to exercise restraint, contending that impeachment is a political accountability mechanism constitutionally entrusted to parliament, and that courts ought not to transform themselves into appellate chambers reviewing parliamentary decisions. The petitioners maintained that while impeachment is undoubtedly political in context and consequence, it remains a constitutionally regulated process subject to constitutional supremacy, the Bill of Rights, and judicial oversight. The resolution of these competing positions requires an examination of the constitutional architecture established under the Constitution of Kenya 2010. The starting point is the supremacy and delegated authority provisions found in the Constitution. Article 1 vests all sovereign power in the people of Kenya to be exercised either directly or through democratically elected representatives. Parliament, the executive, and the judiciary are therefore not sovereign institutions in themselves. They are repositories of delegated sovereign authority, deriving their legitimacy from and remaining accountable to the people. Article 2 declares the Constitution to be the supreme law of the Republic, binding all persons and all state organs at both levels of government. The inevitable consequence is that no state organ, including Parliament, enjoys immunity from constitutional scrutiny. The Constitution of Kenya does not recognize parliamentary supremacy. It entrenches constitutional supremacy, and that supremacy is absolute and admitting of no exception. The Supreme Court gave authoritative expression to this principle in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another 2017 EKLR, where it emphasized that no arm of government is above the law, that this being a constitutional democracy, the Constitution is the guiding light for the operations of all state organs. It further determined that the court's mandate, where it applies, is for the purpose of averting any real danger of constitutional violation. It follows, as a matter of necessary constitutional logic, that whenever Parliament exercises authority under Articles 145 and Article 150 of the Constitution, it does so not as a sovereign body wielding unreviewable discretion, but as a constitutional organ exercising delegated authority within and subject to the limitations that the Constitution prescribes. The jurisdiction of this court to entertain these petitions is firmly grounded in Articles 22, 23, and 165 of the Constitution. Article 165, sub-article 3D, expressly empowers the High Court to determine questions of constitutional interpretation, including whether anything done under the authority of the Constitution or any law is inconsistent with or in contravention thereof, and it is precisely that question that lies at the heart of these proceedings. Article 23 vests in this court jurisdiction to enforce the Bill of Rights and to grant appropriate relief where constitutional rights and freedoms have been violated, are threatened, or are likely to be infringed. The breadth of that jurisdiction is a deliberate constitutional design that reflects the transformative aspirations of the Constitution of Kenya 2010 and the indispensable role assigned to the judiciary as the ultimate guardian of constitutional supremacy and the protector of the rights of every person within the Republic. This court does not approach the jurisdictional question as one of first impression. In its ruling delivered on 31st of October 2024, This bench considered and conclusively determined the self-same jurisdictional challenge that the respondents now seek to resurrect. The court held that the broad jurisdiction vested in the High Court under Articles 23, 22, and 165 extends to determining whether the powers exercised by the National Assembly and the Senate in impeachment proceedings conformed to constitutional requirements. Had the framers of the Constitution intended to exclude the High Court's jurisdiction in matters arising under Article 145, they would have done so in express terms, as they demonstrably did in relation to certain proceedings under Article 144. The argument that impeachment proceedings are beyond judicial scrutiny sits uneasily with the constitutional text. The Constitution contains no provision excluding impeachment from judicial review and no clause creating islands of authority immune from constitutional control. Where allegations are made that constitutional procedures are violated, rights infringed, or constitutional standards disregarded, as in the present case, this court would itself violate the Constitution were it to decline jurisdiction merely because the dispute arises in a politically sensitive context. As Chief Justice Marshall observed in Cohens versus Virginia, 19 U.S. 6 Feet 264, in the year 1821, the court said, "It is most true that this court will not take jurisdiction if it should not, but it is equally true that it must take jurisdiction if it should. We have no more right to decline exercise of jurisdiction which is given than to usurp that which is not given. The one on the other or the other would be treason to the Constitution," close quote. That observation resonates fully within Kenyan's constitutional order. The presence of political implications does not extinguish this court's constitutional duty to interpret, protect, and enforce the Constitution. Even within the argument on separation of powers, this court accepts that impeachment is principally a parliamentary function under Articles 145 and 150. However, separation of powers does not mean separation from the Constitution. As the Supreme Court held in the matter of the Speaker of the Senate and another 2013 KLR, none of the arms of government can claim an exclusive preserve free from constitutional scrutiny, and it is the responsibility of the courts to ensure that the exercise of power by state organs remains within constitutional bounds. The Court of Appeal affirmed in Mumo Matemu versus Trusted Society of Human Rights Alliance and 5 others, that was in 2013, that the Constitution establishes not a rigid wall of separation, but a system of separation of powers tempered by checks and balances within which no arm of government is superior to another. The doctrine therefore requires mutual respect among constitutional institutions, not mutual exclusion, and Parliament cannot invoke it as a shield against constitutional accountability. Within the realm of impeachment proceedings, specifically the Supreme Court in Justice Karaoke Mate and another versus Martin Nyaga Wambora of 2017, the Supreme Court signaled that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the courts is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and not to inquire into how the county assembly and the Senate perform duties in which they alone have discretion, nor to review the merits of the decision to impeach. We are therefore satisfied that this court is being correctly called upon to scrutinize and pronounce itself on the constitutional regularity of the impeachment process. To do so neither impinges upon nor offends the doctrine of separation of powers. As the Constitutional Court of South Africa observed in Doctors for Life International versus Speaker of the National Assembly and others, in quote, while the doctrine of separation of powers is an important one in our constitutional democracy, It cannot be used to avoid the obligation of a court to prevent the violation of the Constitution. The right and the duty of this court to protect the Constitution are derived from the Constitution, and this court cannot shirk from that duty, close quote.